We are now on bail, Rule 114. So, bail is defined under Section 1. Bail is the security given for the release of a person in custody of law, furnished by him or bondsman to guarantee his appearance before the court as required under the conditions hereinafter provided. So, he must be in custody of law, no? And he will guarantee his appearance before the court or by the rules of court when required by the court or by the rules of court. Now, bail may be given in any form, such as um, cash, cash deposit, corporate surety, property bond, and recognizance. Recognizance. So we will talk about these four types of bail now as we move on to the sections of Rule 114. Section 2 talks about the conditions of bail. So all the kinds of bail are subject to the following conditions. First, the undertaking shall be effective upon approval and unless cancelled shall remain in force at all stages of the case until promulgation of the judgment of the RTC, irrespective of whether the case was originally filed or appealed to it. Second, the accused shall appear before the proper court whenever required by the court or by the rules of court. Third, the failure of the accused to appear at the trial without justification and despite due notice shall be deemed a waiver of his right to be present thereat. In such case, the trial may proceed in absentia. Fourth, the bondsman shall surrender the accused to the court for the execution of the final judgment. The original papers shall state the full name and address of the accused, the amount of the undertaking, and the conditions herein required. The photograph, which is a passport size, taken within the last 6 months showing the face, left and right profiles of the accused must also be attached to the bail. Section 3, no release or transfer except on court order or bail. So no person under the detention may by under detention by legal process shall be released or transferred except upon a court order on when he is admitted to bail. Yan. So, bail can be a matter of right, yan ang section 4, or a matter of discretion by the court, section 5. So, let's talk about bail as a matter of right, section 4. All persons in custody shall be admitted to bail as a matter of right with sufficient sureties or released on recognizance as prescribed by law or this rule, before or after the conviction in the MTC, before conviction by the RTC of an offense not punishable by reclusion perpetua or death. Dagdag natin dyan is before the conviction of the RTC punishable by death, reclusion perpetua, or life imprisonment but the evidence is not strong. So kung wala pa or before or after the judgment of the MTC, pwede ka pang mag-bail. Pag sa RTC, before its judgment pero ang iyong punishment ay not death, not reclusion perpetua, nor life imprisonment. Pwede rin naman before the judgment of the RTC of conviction and it is punishable by death, reclusion perpetua, or life imprisonment, but the evidence is not strong. Bail can also be a matter of discretion by the court. So that is Section 5. Yan, Section 5 when discretionary. So, upon conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. So, the application for bail may be filed and acted upon by the trial court despite filing a notice of appeal, provided that it has not transmitted the original record to the appellate court. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, now the application can only be filed with and resolved by the appellate court. Should the court grant the application, the accused may be allowed to continue on provisional liberty during the pendency of the appeal under the same bail subject to the consent of the bondsman. Okay, so pag-usapan muna natin tong bail uh, upon discretion of the court. So sabi niya, bail is a matter of discretion if after the RTC conviction and the punishment is not death, reclusion, perpetua, or life imprisonment. It is a matter of right kung before, no? Before ng judgment of conviction. Pero kung nakapag-decide na, no, ang RTC na you are convicted of a crime that is not punished by death, reclusion, perpetua, or life imprisonment, based on discretion na lang ito. And saan mo daw yan ipa-file? You can file it upon the trial court. No, the trial court, despite filing for a notice of appeal. So kahit umapila ka, pwede mo namang i-file ang iyong bail application for bail sa trial court provided hindi niya pa na-transmit, no, yung original records to the appellate court. Pero kung kunyari sa appeal mo, the offense was changed, no? Ay kunwari if the trial court rendered a decision convicting the accused of a nature from an ano yun? Convicting the accused change the nature of the offense from non-bailable to bailable. So, naging non-bailable yung una, no, na final sa'yo, tapos naging bailable na. Yun na yung decision ng trial court. Yung application mo for bail can only be filed with the appellate court na lang. Yan. So, paano naman kung ang nangyari dati bailable ka, dati bailable yung case mo, tapos nabago at naging non-bailable. So, pwede ba yon? It is not valid. So, pag nangyari yon, you have to question the validity of the judgment because you are now because your right to be informed of the charge of the cause and the nature of the charges against you was already violated. Yan. So, let's move on. If a penalty imposed by the trial court is imprisonment exceeding 6 years, the accused shall be denied bail or his bail shall be cancelled upon showing by the prosecution with notice to the accused of the following other similar circumstances. So, yung following circumstances are bail negating circumstances. So, dito sa part na to, ang pag-uusapan na natin ay yung bail which is not a matter of right nor a matter of discretion. Okay. So, ibig sabihin, hindi pwedeng mag-bail. So, ano yung mga bail negating circumstances? That he is a recidivist, quasi-recidivist, habitual delinquent, or has committed a crime aggravated by the circumstance of reiteration. 2. That he has previously escaped from legal confinement, evaded served sentence, or violated the conditions of his bail without valid justification. 3. That he has committed an offense while under probation, parole, or conditional pardon. That the circumstances of his case indicate the probability of flight if released on bail or flight risk, and that there is undue risk that he may commit another crime during the pendency of the appeal. So those are bail negating circumstances. The appellate court may motu proprio or on motion of any party review the resolution of the RTC after notice to the adverse party in either case. So, yung mga cases kung hindi ka naman pwedeng mag-file ng bail. Yan. So, if the imprisonment is more than 6 years and there are bail negating circumstances, o kaya naman, before the RTC judgment of conviction of an offense punishable by death, reclusion perpetua, or life imprisonment and the evidence of guilt is strong, or after judgment of conviction by the RTC of an offense punishable by death, reclusion perpetua, or life imprisonment. So, dyan sa tatlong yan, hindi pwede. Okay, let's move on to capital offense. A capital offense is an offense which, under the law existing at the time of its commission and of the application for admission for bail, may be punished with death. Section 7, a capital offense of an offense punishable by reclusion perpetua, life imprisonment, is not bailable. No person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when the evidence of guilt is strong, regardless of the stage of criminal procedure. Okay, so the burden of proof in bail application at the hearing of an application for bail filed by a person who is in custody for the commission of an offense punishable by death, reclusion perpetua, or life imprisonment, the prosecution has the burden of showing that the evidence of guilt is strong. The evidence presented during the bail hearing shall be considered automatically reproduced at the trial, but upon motion of either party, the court may recall any witness for additional examination unless the latter is dead. So, the amount of bail naman, the guidelines for the court, no, they must consider the financial ability of the accused to give bail, the nature and circumstance of the offense, the penalty of the offense charge, the character and reputation of the accused, the age and health of the accused, the weight of the evidence against the accused, probability of the accused appearing at the trial, forfeiture of other bail, the fact that the accused was a fugitive from justice when arrested, and the pendency of other cases where the accused is on bail. So we have to only take note that excessive bail shall not be required. So pag-usapan na natin yung different kinds of bail. Corporate surety, so this is any domestic or foreign corporation licensed as a surety in accordance with law and currently authorized to act as such may provide bail bond subscribed jointly and by the accused and an officer of the corporation duly authorized by its board of directors. Sa property bond naman, it is an undertaking constituted as a lien on the real property given as a security for the amount of bail. Within 10 days after the approval of the bond, the accused shall cause the annotation of the lien on the certificate of title on file with the Register of Deeds. If the land is registered, kung hindi naman, in the registration book on the space provided therefore in the Registry of Deeds for the province or city where the land lies and on the corresponding tax declaration in the office of the provincial city and municipal assessor concerned. So within the same period, the accused shall submit to the court his compliance and his failure to do so shall be sufficient cause for the cancellation of the property bond and his rearrest and detention. Section 12, the qualification of sureties in property bond. So each must be a resident owner of the real estate within the Philippines. Where there is only one surety, his real estate must be worth at least the amount of the undertaking. If two or more, each may justify in an amount less than that expressed in the undertaking, but the aggregate of the justified sums shall be equivalent to the whole amount of the bill demanded. In all cases, every surety must be worth the amount specified in his own undertaking over and above all just debts, obligations, and properties exempt from execution. Justification of sureties. So every surety shall justify by affidavit taken before the judge that he possessed the qualifications prescribed in the preceding section. He shall describe the property given as security, stating the nature of his title, its encumbrance, the number and amount of other bills entered into by him and still undischarged, and his other liabilities. The court may examine the sureties upon oath concerning their sufficiency in such a manner as it may deem proper. No bill shall be approved unless the surety is qualified. Okay, so the other type is a deposit of cash bill. So the accused or any person acting in his behalf may deposit in cash with the nearest collector or internal revenue or provincial, city, or municipal treasurer the amount of bill fixed by the court recommended by the prosecutor who investigated the case. Upon submission of the proper certificate of deposit and written undertaking showing compliance with the requirements of Section 2 of this rule, the accused shall be discharged from custody. The money deposited shall be considered as bail and applied to the payment of fine and costs, while the excess, if any, shall be returned to the accused or to whoever made the deposit. Okay, so before we talk about recognizance, because that is under RA 1038-9, let's talk about dito na lang Ayan, yung bail by a bondsman. Ayan, so pwede kasing yung accused or meron siyang bondsman. Ayan, so, okay. So, we have to take note that a notice to a bondsman is also a notice to the accused. So, suppose the appearance of the accused is required in court, but he failed to appear despite notice. What will the court do? Well, the court will issue an order forfeiting the bond of the accused. That is called an order of forfeiture. And so, dahil hindi nag-appear si accused, ayan, mag-i-issue si court ng order of forfeiture in favor of the government. And the bondsman will be required within 30 days. So, within 30 days, the bondsman are required to produce the body of the accused. They have also to show cause why no final judgment shall be rendered against the bondsman for the amount of his bail. And 3, the justification why. Why did the accused fail to appear for the first time? He was required to do so. Yan. So, then, ayun nga, no, order of forfeiture kapag hindi nag-appear ang akusado. Yes. And then within 30 days, the bondsman will be required to produce the body of the accused, show cause why there should be no final judgment to be rendered against the bondsman, and show why the accused failed to appear the first time that he was required to do so. Ngayon, if the bondsman fails to do this, no, the failure of the bondsman to do this within 30 days, the court shall order the confiscation of the bonds. So, yun na yung, so third is the order of confiscation in favor of the government. So, may the accused, question, no, may the accused be arrested even if he is on bail? Yes, of course, no? If he attempts to depart from the Philippines without permission from the court where the case is pending. Okay, so now let's move on to recognizance. Ayan. So, recognizance, whenever allowed by law or by these rules, the court may release a person in custody to his own recognizance or that of a responsible person. So, recognizance is under RA 1038-9. So, who are the persons that can be released on recognizance? So, one, we have if the accused is a youthful offender or CICL. Two, if it involves only light offenses. 3, if the accused has been detained equal to or more than the minimum of the imposable penalty. So, nakulong ka na more than the minimum, pwede ka nang mag-recognizance. But take note no dito, paano kung yung ang naikulong mo na ay yung maximum penalty. So, kung ganon, kailangan pakawalan ka na. Kasi even if naman na ma-convict ka of the crime, na-serve mo naman na yung sentence. So, dapat released immediately ka na. Ayun. So, next naman, no, the accused applies for probation and is unable to post bail. And then, fifth, if the accused is entitled under 1038-9. So, in all offenses not punishable by death, reclusion perpetua, or life imprisonment, this is a matter of right. Okay. So, Section 16, bail when not required. Reduced bail on recognizance. So, no bail shall be required when the law or these rules so provide. When the person has been in custody for a period equal to or more than the possible maximum imprisonment prescribed for the offense charge, he shall be released immediately. Ito yung sinasabi ko kanina. He shall be released immediately without prejudice to the continuation of the trial or on the proceedings on appeal. If the maximum penalty to which the accused is sentenced is destierro, he shall be released after 30 days of preventive imprisonment. A person in custody for a period equal to or more than the minimum of the principal penalty prescribed by the offense charge without application of islaw or any modifying circumstances shall be released on reduced bail or on his own recognizance at the discretion of the court. So now let's talk about where do we file bail? Where? Section 17. Yan. Bail in the amount fixed by may be filed with the court where the case is pending. Ayan. So, one, where the case is pending, or in the absence or unavailability of the judge thereof with any RTC, MTC in the province, city, or municipality. If the accused is arrested in a province, city, or municipality other than the place where the case is pending, bail may be filed with any RTC of the said place, or if no judge thereof is available, with the MTC judge therein. So when the grant of bail is a matter of discretion, and, or the accused seeks to be released on recognizance, and the application may only be filed in the court where the case is pending, whether on PI, trial, or on appeal. So, if upon discretion ang bail mo, or gusto mo recognizance ka ma-release, doon lang sa court where the case is pending. 3. Any person in custody who is not yet charged in court may apply for bail with any court in the province or city where he is held. So, nangyayari to sa mga valid warrantless arrest, Yan. So, no charge yet. Di ka pa na charge yan. So, any court kung saan ka ikinulong. Yan. So, meron naman kung upon discretion, there is no transfer yet of the fourth, if the bill is a matter of discretion, the application for bail may be filed with the same RTC notwithstanding notice of appeal has already been filed, provided that no transfer of records has been made to the appellate court. A matter of discretion, the accused is convicted with imprisonment not punishable by death, reclusion perpetua, or life imprisonment. So, file with the same RTC notwithstanding notice of appeal has been filed. The court has already lost its jurisdiction. It may still act on the bail application in the exercise of its residual jurisdiction, provided the records are not yet transmitted. Otherwise, bail must be filed with the appellate court. And fifth, kapag the judgment of conviction changes the nature of the offense from non-bailable to bailable, the application of bail shall only be filed and be acted upon by the appellate court. Let's move on. Notice of application to the prosecutor. If the application for bail under Section 8 of this rule, the court must give reasonable notice of hearing to the prosecutor to require him to submit his recommendation. Release on bail. The accused may be discharged upon approval of the bail by the judge with whom it was filed in accordance to Section 17 of this rule. Whenever bail is filed in a court other than the court where the case is pending, the judge who accepted the bail shall forward it, together with the order of release and other supporting papers, to the court where the case is pending, which may for good reason require a different one to be filed. Increase or reduction of bail, pwede yan. After the accused is admitted to bail, the court may, upon good cause, either increase or reduce its amount. When increased, the accused may be committed to custody if he does not give the bail in the increased amount within a reasonable period. An accused held to answer a criminal charge who is released without bail upon filing of the complaint or information may at any subsequent stage of the proceedings and whenever a strong showing of guilt appears to the court be required to give bail in the amount fixed or in lieu thereof committed to custody. Section 21, Forfeiture of Funds. So, ito yung kanina sa bondsman, When the presence of the accused is required by court or by the rules of court, his bondsman shall be notified to produce him before the court on a given date and time. If the accused fails to appear in person as required, his bail shall be declared forfeited and the bondsman is given 30 days within which to produce the body of the accused and to show cause why no judgment should be rendered against them for the amount of their bail. Within the said period, the bondsman must produce the body, explain why the accused did not appear before the court as required. Failing to these two requisites, a judgment shall be rendered against the bondsman, jointly and severally for the amount of the bill, and the court shall not reduce or otherwise mitigate the liability of the bondsman, unless the accused has been surrendered or acquitted. So next, let's move on to the cancellation of bail. So in cancellation of bail, it can either be automatic or by motion. Yan. Ito, automatic or by motion. So, for the purpose of surrendering the accused, the bondsman may arrest him or upon written authority endorsed on a certain copy of the undertaking, cause him to be arrested by police officer or any other person of suitable age and discretion. An accused released on bail may be rearrested without the necessity of warrant if he attempts to depart from the Philippines without permission of the court where the case of is pending. So, automatic ang cancellation ng bail if the accused is acquitted, if the case was dismissed, and when there is already a final judgment of conviction. It is by motion if the accused surrendered or upon the death of the accused that the bondsman must show proof of the death. So, hindi yan picture, no? Na namatay siya. Death certificate. No bail after final judgment exception. No bail shall be allowed after the judgment of conviction has become final. If before such finality the accused has applies for probation, he may be allowed temporary liberty under his bail. When no bail was filed or the accused is incapable of filing one, the court may allow his release on recognizance on the custody of a responsible member of community. In no case shall bail be allowed after the accused has commenced to serve his sentence. So, di ba pag may finality of judgment, hindi na nga pwede ang bail. Pero kung nag-apply for probation si accused, he may be allowed to fix bail. Kung hindi niya kaya, pwedeng by recognizance. Court supervision of detainees. So, syempre, the court has to exercise supervision on all persons in custody for the purpose of eliminating unnecessary detention. So, merong monthly report kasi yan and visitations yung mga judges to in penal institutions, no? Yan. So, lastly, Section 26, bail is not a bar to objection on legal arrests. So, an application for admission for bail shall not bar the accused from challenging the validity of his arrest or the legality of the warrant issued therefore, or from assailing the regularity or questioning the absence of a preliminary investigation of a charge against him, provided that he raises them before entering his plea. And so, i-raise mo before entering his plea, and the court shall resolve the matter as early as practicable but not later than the start of the trial case. So, that ends bail.